Hi, my name is Andrew Meinzer of Meinzer Law Firm. We take care of people all across California who are planning to ensure that things go as they want when they die or become unable to take care of themselves anymore. The information that I'm about to provide is based on current California law. It's general information and it's not specific legal advice. Today, I'll talk with you a bit more about your heirs. Your heirs are the people who will receive your assets when you die if you don't do anything to specify the people to receive your assets at the time. This is the 7th video in an 8-part video series. If you live in California, then your heirs are defined by California law. Your heirs are the people who will receive your assets after your death if you haven't specified otherwise. We determine who your heirs are not while you're alive, but at the moment of your death. That determines who your heirs are. And let's just say let's talk about what happens when an heir dies after you die. So if an heir of a decedent, let's call that heir decedent 2, dies after the death of the decedent, but before receiving all the assets she's entitled to receive from the decedent, then the assets of the decedent, that decedent 2 has not yet received but was supposed to receive, will transfer to the people that decedent 2 has specified to receive her assets after her death. And just as with the first decedent, if decedent 2 has not specified that, then those assets of the decedent will transfer to the heirs of decedent 2. Now, why does California have laws defining heirs? The answer is because California has a public policy to avoid having assets perpetually stuck, titled in the name of a decedent. If assets are titled in the name of a decedent, then nobody has control over them. The decedent, on paper, owns them, but of course the decedent cannot control them because he or she is deceased. So accordingly, nobody can use and enjoy those assets or make those assets part of the California economy. Similarly, nobody has an obligation to maintain such assets and keep them safe, which is important in terms of things like real estate and vehicles. The California heirs statutes go a long way toward fulfilling that public policy of not having assets get stuck perpetually titled in the name of a decedent. They almost always, California law heir statutes almost always prevent the asset from being perpetually stuck titled in the name of a decedent simply because the decedent did not specify who will receive his assets after his death. California has an unclaimed property division of the state controller's office. The unclaimed property division holds unclaimed assets of decedents who did not specify who will receive their assets after death and who had no heirs at death. Planning ahead for transfers of assets after your death can be very complicated. There are many factors to consider, including who you want to receive your assets. Also consider how easy you want to make things for your relatives after you die. If you don't do this correctly, then you may create confusion and even conflict among your family members after your death. Hiring an attorney experienced with California transfers of assets after death is critical for obtaining the results that you need. In addition, the advice and guidance of an attorney experienced with transfers of assets after death is invaluable in these cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients with transfers of assets in California. Again, I'm Andrew Meinzer of Meinzer Law Firm. If you know that you need our help with estate planning, transferring assets at death, or even if you just have a question, please contact us and let us take care of you.